Have you ever wondered whether there's actually anything you can legally do about inheritance tax, or whether it's just something that lands on your family after you've gone? Or have you heard people mention allowances, gifts, and the 7-year rule and thought, fine, but how do any of those actually fit together? Look, by the end of this video, you'll have the whole map in one place. The 5 main legal ways to reduce inheritance tax through estate planning. Now, there are more advanced arrangements out there, and some of them are right for some people, but that's a conversation for after someone has actually looked at your position properly. These are the 5 foundations, and they come first. They apply to almost everybody, and if they're not right, nothing you build on top of them works either. And I'll finish with one mistake that quietly undoes all of them. I'm Gary from Westwood Estate Planning, so let's talk about it. Let me clear something up before we start, because it puts people off before they even begin. There's an assumption that reducing inheritance tax means something clever, something offshore, something a bit murky and not quite above board. It really doesn't. Nearly all of it is allowances Parliament has already handed to you and rules that already exist. The work isn't finding a loophole. It's using what's there deliberately and in the right order. So let's start with number 1. Start with the allowances that you already have. So every person has a nil rate band of £325,000. On top of that, if you leave your home to your children or grandchildren, there's a further allowance of up to £175,000, the home allowance. 2 separate allowances, each with its own conditions, and the home one isn't automatic. It depends on how your will is actually written, and look, I've seen older wills that quietly do put this one at risk. Both of those allowances are frozen until April 2031, while house prices carry on doing what house prices invariably do. I've made a full video on the home allowances, and I'll link to that in the description. It's the first place I'd look. So number 2, give it away and live 7 years. Hand something to a child or grandchild, survive another 7 years, and it generally falls out of your estate altogether. No tax on it at all. Don't survive the 7 years and it can be pulled back in, with the bill landing on the person who received it. That catches families out more than anything else I see, because nobody expects the tax to follow the gift. And number 3, give from income, not capital. This is the one that most people have never heard of, and it may well be the most useful of the lot. If you have more income coming in than you actually spend, you can give the surplus away regularly, out of income, not out of savings, without denting your own standard of living, and it's exempt immediately. No 7-year wait, no upper limit. It lives or dies on your records though. HMRC will want to see the pattern, and it's your executors who have to prove this after you're gone. Number 4, the everyday exemptions. £3,000 a year, £250 to as many people as you like, wedding gifts, and anything at all between spouses. None of it dramatic on its own, all of it's free. And over 15 or 20 years, it adds up to a number that can surprise people. And lastly, number 5, leave something to charity. Anything that you do leave to a UK charity is free of inheritance tax. And there's a second part to it too. Leave at least 1/10 of your taxable estate to charity, and the rate charged on everything else drops from 40% to 36%. So if leaving something to a charity is already on your mind, the rules reward doing it properly. Exactly how that works out for your family depends on the numbers, and it does deserve a video on its own. But look, that's the shape of it. And I did say I would talk about the mistake that undoes all of it. So look, if you do give something away, but you carry on enjoying it, it doesn't count as given away. The classic example is the signing the house over to the children and staying put in that house rent-free. As far as HMRC is concerned, you never gave it away at all. It sits in your estate and it's taxed in your estate. Years of good intentions and no effect whatsoever. Those 5 do not sit in separate boxes. Give from capital when you could have given from income, and you've started a 7-year clock you never needed to start. Use your everyday exemptions quietly for 20 years and you've moved a serious sum with no clock at all. And a will written 15 years ago could cost you the home allowance without anyone noticing. That's why the answer to what should I do about inheritance tax is almost never one of these 5 on its own. It's which of them apply to you, in what order, and whether everything you've got in place already points in the same way. Someone has to hold that whole picture, and that's the job. So if you'd like someone to look at your situation, there's a link down below. So look, thank you so much for watching this video. I'm Gary from Westwood Estate Planning, here to protect your family and secure your peace of mind. If these videos are useful to you, a like to the video helps more families find them, and subscribing to this channel means that you won't miss what's coming. We cover a new estate planning question regularly, so stay tuned. And bye for now.